Basically, I'm thankful to ICSI for giving me this opportunity to present the topic in front of the esteemed members and insolvency professional, seniors, and my dear friends. Good morning to all of you. Prior to that, I have been on this ICSI forum in a local branch. So this is the second opportunity given in which it is a special group of insolvency professionals. I can take a note that senior IPs like Anil Melanzis and many others have joined this lecture today. So, friends, as we are aware that initially in the year 2016, when this code was absolutely new, some of my CS friend itself told me that this is what is coming new in the market. So I dared to appear for the exam. At that time, I didn't know that I will have to full time devote to this practice. But after getting through in 2017, it was there were very less number of IPs at that time, and the workflow was tremendous. And so after 25 years of my chartered accountancy practice, now since last about 8 years, I am a full-time IP practitioner. So basically, as we have seen, that any new enactment which is coming, like at that time, GST was also new, which came from July 2017. And IBC, as we are aware, that it was approved by the Parliament on 20th of May 2016. And subsequently, in October 2016, IBBI was formed. Even the various tribunals, like NCLT, was established since 2016. And the actual play started from, I can say, 1st December 2016. So it was a well drafted code which has been drafted from various other acts which were prevailing at that time, as we all know. But at the same time, madam, I can share my PPT. Let me see. Just a moment. You are able to see it properly? Yes, can anyone say?
Yes, sir, we are able to see.
Yes,
Okay.
it's
Okay.
visible.
Yeah, thank you. So, just a moment. So actually, the IBC was enacted in 2016, and basically thereafter, like any other law, it has some initial teething problems. It had some practical challenges that were encountered during the implementation. And as we all know that it was a shift from debtor in control to creditor in control with strict timelines and waterfall based distribution to promote time bound resolution. And however, the earlier issues included ambiguities in terms of eligibility, delays due to litigation problems with home buyers' rights, promoters' interference, difficulties in MSME resolutions, and weak institutional infrastructure. So basically, Operationalizing the code quickly exposed certain gaps. So the gaps were, as I told, that eligibility of applicants. There were issues relating to interpretation of moratorium, treatment of home buyers, promoter influence via Section 29A, lack of clarity on distribution of resolution proceeds, challenges with MSME insolvency, treatment of personal guarantors, abuse of CIRP as a recovery tool, delays due to excessive litigation. Subsequent amendments targeted these issues directly. So now I will take you because basically, in order to ascertain what are the problems, as the topic for today is what are the problems that are persisting and yet to be resolved in toto. Before that, I purposely selected that what were the earlier problems that were dealt with and addressed. So let us first go through in these 7-8 years what were the problems which were faced initially and which were overcome by way of various regulations and amendments. So, 5 major amendments have taken place between 2017 to 21, and recently also some amendments have been made. So, we will go through these amendments one by one. The first major problem was Section 29A. So, the problem was defaulting promoters and related parties were bidding for their own companies at deep haircuts and regaining controls. So persons with NPA acquiring companies at discounts. So these were the problems which were not anticipated, and that is why Section 29A was introduced. So the first amendment was introduced on 23rd November 2017 by way of inserting Section 29A in the code that led to exclusion of promoters and their related parties from corporate insolvency resolution process. This provision eventually led to exclusion of promoter and its group entities. So some mega corporate entities like SR Steel, and Bhushan Steel, and this proved to be really a game changer. But friends, in this also, by way of introducing this section in 2017, did not suffice the purpose because there were some loopholes which were remaining in the introduction of 29A. So the second amendment was required to be carried out, which was carried out in June 2018, wherein the related party and relative in context with the provisions of 29A were defined properly. So section 240 was also introduced to exclude micro, small MSME from the application of clause C and H of section 29A. So that is how we can see that the government was proactive in making the changes which were faced in the practical implementation of IBC. And as a result, the impact was it ensured a clean and fit applicants, improved the fairness and credibility of CIRP. The next unattended thing was relating to the home buyers, which had no status as financial creditors. So the problem was real estate allottees were treated as unsecured operational creditors without any voting right. So as I remember, probably in 2018, a case of JP Infra was there where this necessity was felt that among the broad category of filing the claim, basically they didn't had at that time a separate claim form, because what existed that time was the form for submission of financial creditor, operational creditor, workman, and all other types, but it didn't had any form for submission of claim by the home buyers. So this was attended, and an amendment was brought in the year 2018. So an explanation to section 58F was introduced, wherein the home buyers were classified as financial creditors. They can file CIRP under section 7, and they were entitled to have a vote in the COC through authorized representatives. So as we will see later on, that even the provision relating to the home buyers was made in the code. It further was required to be amended, which was later on amended. I will discuss it at that time. But with this, it strengthened the consumer protection and prevented misuse by the builders. So landmark Supreme Court case in this is the Pioneer Urban versus Union of India in 2019. Next issue was there was no mechanism into existence to withdraw CIRP after admission. Now, a separate amendment was carried out in the amendments that were made in 2018, wherein section 12A was introduced. So the problem was the debtor and creditor, even they mutually agreed to settle, CIRP could not be withdrawn after admission. That was the difficulty. So with introduction of section 12A, CIRP could be withdrawn with a 90% COC approval. Next issue was the COC decisions were challenged in the courts. So basically it lacked commercial finality, and resolution, it was resolved by way of amendment to section 30 subsection 2 and 31, plus the directives given in the SR Steel judgment. So the problem at that time was NCLT and NCLAT were modifying the resolution plan and interfering with COC's decision. So basically, it was at the initial stages that these problems were anticipated. But I remember one case which was dealt by me, because I have prepared a resolution plan for one of the resolution applicant. And after this amendment came into existence, my resolution plan was approved by the bench in the year September 2020. In spite of that, while the hearing on the plan was taking place, I was surprised to note that bench has technically interfered in the resolution plan which was approved by the COC in terms that I will read a few lines from that during the course of hearing, it became apparent from the schedule of payment provided in the resolution plan that the payment proposed to be made by the resolution applicant by the 270th day from approval of resolution plan was a mere commitment without adequate security backing from the resolution applicant. So all sides felt that this unsecured commitment by the resolution applicant may compromise the feasibility and viability of the resolution plan. In light, this bench asked RP, RA, and COC to apply their minds on this aspect and renegotiate on the terms of payment proposed in the resolution plan. As a consequence of the same, the RA improved its offer as detailed below. So basically, according to me, because of some adjustments in the payment plan, the plan was going to be approved, and therefore we did not object to the views taken by the honorable bench. But according to me, even at that time, it was basically none of their requirement or business to go into detail for the commercial decision that was taken by the COC. The COC constituted mainly of Bank of Baroda. So they were competent enough to take the decisions. But subsequent to this observation, we made certain changes, presented it before the bench, and the case was approved. So basically, that even if you can note that in the initial couple of years, there were a lot of, because see, the entire ecosystem was new. As I said, the regulator came into existence in October 2016. Similarly, the adjudicating authority also came into existence in 2016. And there were a lot of confusion in the entire ecosystem. There was a lot of interpretational differences. So that is why these things happened. But that is how they were dealt with, and the loopholes were properly plugged. So COC's decisions were getting challenged, and the court has clear cut, given that the COC's commercial wisdom is non-justiciable, except limited judicial review. NCLT cannot rewrite or modify plans. This was reinforced in the Supreme Court judgment in SR Steel. Just for the purpose of you to understand, I have taken reference of a few important cases that you can note. Next issue was relating to the MSME promoters who could not bid for their own companies because of Section 29A, even when no fraud existed. So for accommodating them, a pre-packed insolvency resolution process, PPIRP, was introduced, which allowed the MSME promoters to propose a base plan, and it was a faster turnaround of about 120 days, and therefore was more flexible. But later on, we can see about this PPIRP has till now has not gained any much popularity. So, however, it was introduced for the convenience. Next issue was relating to the considerable litigation on the treatment of operational creditors. So this issue was resolved by way of amendment in 2019. So the case reference is SR Steel, decided by Supreme Court. And there the operational creditors demanded equal treatment to the financial creditors. But basically, it was resolved, it was ordered by the Supreme Court that a minimum payment guarantee for OCs be given and Supreme Court held that equality does not mean equal. So differential treatment was permitted. So as we were evidencing the growth of various cases during that time, I remember that one Mr. Mukhopadhyay, who is a famous bench member, he had a bit inclination because at that time OCs were not getting anything from the plan, and he insisted that he was more toward the favorable toward the operational creditors. So what happened that subsequent to the judgments which were passed by the bench of NCLAT, a clear-cut direction was required to be made for the operational creditors. And now we see that even in the resolution plan, the operational creditors are getting something because of that amendment. So operational creditors basically were at the problem. I remember in another resolution plan, which I have prepared for one of the RA, at that time, when I was representing in the COC, so in the first round, we have given X amount to the consortium bankers, and we have given some amount towards the operational creditors, particularly the suppliers of that entity. The logic of my resolution applicant who discussed with me was that in spite of passing the resolution plan or approving the resolution plan, he said, sir, I will be required to do the business with almost the same set of suppliers which were earlier providing material or other things to the entity. And that is why he said that you give a bit of more weightage from whatever amount I have decided, and the balance will be toward the financial creditors. So even though in BLRC, particularly while keeping the composition of COC, it was at that time felt that the OCs normally should not be there in the COC only because they have a narrow and limited view about recovery of their money. But when I represented in COC, I could see that even the bankers are not interested in any other factor other than the recovery of their dues. So to that extent, the BLRC's proposal that bankers and financial institutions be there as a secured or unsecured financial creditors in the COC, practically it was not made, and I was asked to reduce the payment of OC and improvise the payment which is allocated to the financial creditors. Friends, what I feel is it is a type of monologue that is being happening. So if you want to raise any queries or discuss anything in between, I don't have any problem, because earlier what it used to be is that we used to face a physical audience in which the reactions and all other things could be read from the face. But with this type of facility, online facility, it becomes really very difficult for me to understand whether you are getting the topic or not. And even if you are having queries in between, you can straight away put on your video and audio and discuss something if required. So with this, I move to the next issue that was relating to the delays. Delays due to Section 7 threshold by individual home buyers. So as I told you before, that the provisions relating to the home buyers was made, they were treated as secured financial creditors and were therefore entitled to become COC member. But it was observed that multiple individual home buyers were filing Section 7 application and were paralyzing the real estate companies. So there was a necessity, and therefore the ordinance came into existence in 2020 that the minimum threshold for large home buyer groups should be 100 allottees or 10%, whichever is less, needed to file Section 7 application. So now at present, the applications are being filed by home buyer on the basis of this. So as we have seen that in case of 29A, after introduction also it required amendment for defining the relatives and interested related persons. Similarly, after introduction of provision relating to the home buyers, it became necessary to define how much number of home buyers are required to file an application under Section 7. Basically, this real estate sector is also not very foolproof as such under IBC, even as of today. But as the problems are coming, they are being dealt with. Next issue is relating to absence of clear framework for insolvency of personal guarantors. So earlier, the problem was no ability to proceed against personal guarantors in IBC. So as it was in existence during 2018, there was a problem in proceeding against the personal guarantors in IBC. So central government notified Part 3 for personal guarantors to corporate debtors. And as we can see that the personal guarantors of a corporate debtor are being dealt with by the adjudicating authority, that is NCLT. So in the Lalit Kumar Jain case in 2021, the Supreme Court clearly stated that CIRP does not relieve the personal guarantor. I also remember in the initial period, probably in 2018, there was a case decided by Guwahati or Kolkata bench in which it was relating to the FACOR Limited. When what State Bank did at that time was, State Bank, instead of starting the CIRP of the company, they straight away approached with the guarantors of the corporate debtor. So at that time, the case was very much discussed, and whether the sequence should be like first the corporate debtor should be dealt with, and then for the balance recovery amount, whether the personal guarantor should be taken into the court of law. But it was decided that there is no sequence as such, and bank may choose to start with recovery of amount from the guarantors of the corporate debtors. Next is the amendment was carried out in 2018 and 19 amendment. The critical decisions reduced from 75% to 66%. That is for approval of resolution plan. And routine decisions reduced from 75% to 51%. Of course, this was beneficial from the voting point of view. Then the next issue was low success rate in resolution due to unrealistic timelines. This timeline is a very big area, to be discussed. But in 2019, amendment was made that the CRP should be completed within 330 days. That was the overall limit. And basically 270 days plus another 60 days towards litigation. So the statutory cap was 330 days, including the litigation period. So, and Supreme Court took it that it is directory in nature, and therefore we can see that still there are majority of the CRP which are being carried out even exceeding this period of 330 days. I am going to show you the statistics later on. So this amendment was made. Then there were certain issues that applications were rejected due to minor procedural defects. But as such, there was no way out for curing these defects. And therefore, the NCLT was empowered to allow rectification of defects, and Rule 11 was amended. So this issue was overcome. Then there was no clarity regarding the treatment of government dues and statutory claims. So in 2020 amendment, and you can also go through the Supreme Court Ganesham Mishra case, wherein the government dues that are not in approved plan stand extinguished once the plan is approved. So that clarity was also made. Basically, what happened, since I belong almost from the starting of the code, it was very difficult for others to explain the code that these things have came into place. So we have to educate lot of bankers and others. Yes, Ashish? Your voice is not audible. You unmute yourself.
Yes, sorry. Good morning, sir.
Good morning.
Sir, I have one small query regarding this Ghanshyam Das Mishra case you mentioned. The government dues all stand extinguished. So if there is a matter where you have acquired a company through IBC route, and along with there is a subsidiary, 100% subsidiary, which is actually the main company in which the assets were, the value of the assets were locked in that subsidiary, and the acquisition took place through the holding company. Now, what happens to the liabilities of the subsidiary? If there are, because in the resolution plan, it is clearly stated that no liability or no non-compliance of the subsidiary will be action taken against the resolution applicant or successful SRA. So my question is, sir, what happens to the liabilities of the subsidiary which actually come along with the acquisition? While the Ghanshyam Das Mishra case and all other matters, there is no point risen about the subsidiary liabilities. While the resolution plan, it is clear that nothing is payable.
So basically, till now, I have as such not dealt with the situation which you are elaborating. But as the logic goes, that if the resolution plan is for takeover of the entire holding and subsidiary company together, in that case, there is no question about entertaining a separate liability for the subsidiary company. That is what the provision says. And the government liabilities stands permanently extinguished by the approval of the resolution plan, with the approval of the resolution plan.
Yeah, so the plan has been approved, and the specific reliefs and concessions have been asked for, where it has been written that the company, under CRP, along with its subsidiaries, no liability shall be carried forward.
Yeah, so that is what normally we do, that while making the resolution plan,
Yes.
we clearly put these things on record so that if it is not touched by the bench while approving the resolution plan, so it has to be followed. And sir, basically what we have seen is, in spite of that, we are facing, means the resolution applicant is facing various problems to explain the GST department, excise department, the customs department, and the income tax department. So these were the initial problems, but nowadays many of the government departments have understood the law with passage of so many years.
Yeah.
But still the problem lies with the electricity companies, with the local authorities about the taxation matters. So the problem that way is still persisting, and the resolution applicant is required to face these problems, go on explaining them, and later on, since the provision is there, it will always prevail.
Mhm.
So the next thing was,
Thank you, sir.
the lack of clarity for avoidance transactions. That amendments were carried out in the 2018 amendment on this preferential undervalued fraudulent. Next is no mechanism for cross-border insolvency. Now, draft 2023 amendment has been there, in which the UNCITRAL, that is United Nations Commission on International Trade Law. So, these amendments have aligned as per this model, but still the problem persists because it is not yet fully implemented, but the groundwork is ready, and these were the immediate roadblocks which were removed for effective implementation of IBC. So basically, as we can see, I will discuss under this later on about the cross-border insolvency, how it was dealt in the Jet Airways and Kingfisher case. So problems are still there in the cross-border insolvency. So friends, basically this was the background, particularly of the important problems that were faced immediately after in the couple of years, immediately after the implementation of the resolution plan, IBC. Now, next we will discuss is the main topic which is there for today is the persisting problems, means the problems which are yet not resolved. So the first and foremost problem is delays in CRP far beyond the statutory timelines. The 330-day outer limit is rarely met. So probably now from these problems onwards, all of us will be able to correlate that yes, these problems are still into existence, and it needs to be seen that how these problems can further be reduced. So I got the data for June 30, 2024, wherein approximately 1,249 ongoing cases were there. And out of that, which had exceeded the outer limit of 330 days. So they represented about 63% of the total 1973 ongoing CRP at that time. So 63% is a major percentage, and CRP was not completed within the prescribed statutory period of 180 or 270 or 330. The 330 days period is intended as the maximum time for the entire resolution process, including extensions and time spent in legal proceeding. However, this data indicates that adherence to this timeline still remains a significant challenge. So we can go through few of the cases that SR Steel. So Supreme Court acknowledged the chronic delays and stressed strict adherence to 330 days. Despite this, many CRP exceeds 2 to 4 years, proving the issues persist. In ArcelorMittal versus Satish Kumar Gupta, court expressed concern over the time lost in litigation. In Surendra Trading Company, Juggilal Kamlapat, Supreme Court held timeliness are directory and not mandatory, which contributes to continued delay. So this is the persistent problem that timelines remain the biggest unresolved challenge. Frequent adjournments, valuation disputes, 29A appeals, and NCLT backlog continue to derail the 330-day objective. Heavy pendency in NCLT benches and frequent adjournments, complex litigations drag on for months or years. So as of September 25, there are about IBC 15,000 such cases. So looking at the number, I don't hope that this timeline will ever be met, or even the average percentage can get reduced, because many of us are observing on a daily basis. Particularly, I am more connected with the Mumbai bench, and in the initial years, it was a very tremendous workload on them, and therefore the hearing ability was very less. The bench itself used to hear it very fastly and proceed for the next case. So under such circumstances, but at that time, I had few cases in Cuttack bench and other benches. So the work pressure was not that much. The bench was hearing all the cases very quietly. But the problem exists with the NCLT, and I don't know how the timelines will get reduced. Next, I have taken data from the IBBI quarterly reports, which are being published on IBBI website. So this is the position available for as of 30th June 2025. So first is the status of CRPs. So if you can see, the total is 4,002, in which it was initiated by FCs. The total number is 8,492. And OCs, it is 3,963, CD 522, and financial service provider 5. So this is the number. Then CRP yielding resolution plan, that is also explained, and CRP which has gone into liquidation, that is also there. You can go through that data. It is not important to discuss. So basically, the code endeavors to close the various process at the earliest. The 1,258 CRPs which have yielded resolution plans by the end of June 25. Take a note that it took an average 602 days after excluding the time excluded by the adjudicating authority for conclusion of process, while incurring an average cost of 1.1%, 11% of liquidation value, 0.63% of resolution value. So if you can see that minimum average days that are required is almost 600 days. Similarly, in 2008-24 CRP, which ended up in orders of liquidation, took an average 512 days for conclusion. See, these are certain things which are not, which cannot be imagined, that why so much of delay is taking place. It is difficult to understand. Why? Because liquidation is immediately taking place in following cases, that if there is no resolution plan and the time period has finished, then the RP is bound to make an application in spite the COC has not mandated for liquidation, because he is bound by the law to make an application. In one of my cases, I have made the application and COC has resolved for extension. That extension was later on placed by me, and it was the bench for to decide, and the matter is still going on. But the important point which I wanted to draw is, when the liquidation, if there is no resolution plan, if it has been specifically resolved by the COC to liquidate the company, so at least in these cases, there should be an immediate order, or I can say it should be dealt with in a very short span and should not be taken for such a long time, because ultimately, as we know, that whenever more time is involved, there is a great amount of depletion in value of asset, and therefore it is necessary for bench. Because earlier I also had one idea in mind, and I don't know, because I am not a person from law side, but we are having 6 benches in Mumbai. So whether it can be planned like a specialized bench, means particularly a bench will deal only with the admission cases. Another may deal only with the plans which are required to be approved. Another may deal with only the cases which are required for liquidation. That type of category, if made, then probably, according to me, that's my opinion, that it will be easier for the bench member, because one after the another, the cases which are coming in front of them will be only the cases which requires, say, admission or for approval of resolution plan. So it will be a expertise type of bench. But till now, nothing of this sort has happened. So further, in 1439 liquidation process, which have closed by submission of final reports, took an average of 651 days for closure. Even in 1746 voluntary liquidation case, which have closed by submission of final reports, took an average 400 days for closure. So basically, that problem lies with the judiciary, because they are overburdened with the number of cases, and therefore such things are probably happening. And therefore, so much of time span is required. I have taken another details about the average time for approval of resolution plan and order for liquidation, which was reported in the quarterly newspaper of IBBI. So from ICD, means the insolvency commencement date, to approval of resolution plan by adjudicating authority. From insolvency commencement date to order for liquidation. So this is the categorization. Similarly, in liquidation, from the liquidation commencement date to the submission of final report. Similarly, the next is for voluntary liquidation. So you can see that there is a huge delay that is taking place. This pictorial representation probably would be able for you to understand in a much better way. We will just see that about 7% of the ongoing CRPs are there between less than 180 days period, and out of that, the other is they are exceeding 90 days. So they have made the classification as exceeding 90 days, 9%, 90 to 180, 7%, 180 to 270, 6%. So all these three categories are well beyond their legal limits. And the next category is 270 days, they are 78%. There are basically capacity constraints of NCLT and NCLAT. So as of late 2024 and early 2025, the NCLT had total deficiency of approximately 19 members against its sanction strength of 63, one president and 62 members. So this has been explained in the chart which is given. High volume of insolvency, company law and other matters filed under the same forum is one of the results, which is resulting into the backlog and affect the time-bound resolution, which is the central feature of the IBC. Now, let us discuss about operational creditors, and still they receive very low realization. So most resolution plans heavily favor financial creditors. As I told you earlier, the reason, because the COC and the decision is in their hands. Despite of Swiss ribbon and subsequent ruling, OC recovery is often negligible. Many MSME find IBC unfair or ineffective as a recovery mechanism. So basically, it is not a recovery mechanism itself, has been cleared in many cases that IBC is not a recovery mechanism. So even though recovery of total claims under the code averaged about 32% with a median of 24%. So median recovery for operational creditors has remained as low as 6%, according to the report that was prepared by Insolvency Law Academy in collaboration with E&Y and law firm Chandilok and Mahajan. So in this report, they say that when considering the cases with some of the largest approved plan, means greater than 2,500, the average recovery of 34% with a median of 29% to financial creditor does witness an uptick to average recovery of 46% with a median of 42%. But the median recovery for operational creditor follows a similar trend at 5%. So in any category, big or small, the operational creditors recovery percentage remains very poor. Basically, I have a new idea about looking at it. I would try to explain that the mechanism states that COC is at the center of taking all the important decisions along with the IRP or RP. But when you look at that, when the cases are coming to IBC, it necessarily has a gap between its assets and liabilities. So if assets are 100, your liability may be 200 or 300 or even 400. I feel that the banker who is sitting at the helm of affairs, I'm sorry to bankers if they are present today in the audience, but you look at it that initially when the business started, so probably normally the terms are like if 100 is the requirement, 25 or 15 or 10, whatever percentage will be the margin, and rest will be contributed by the financial institutions, more particularly the banks, maybe a term loan or working capital limit. So maybe for 4 years, 5 years, 10 years, 15 years, the business was into operation. And as per banking regulation, it is expected that the bank will be monitoring the business in their own interest because they are the maximum contributors, not by way of equity, but by way of loan. So now in so many years, when the bank is sitting along with the corporate debtor, the way these gaps have arrived, then who is responsible? Like if 100 is the asset and 400 is the liability. So initially, what was the ratio? 100 was the asset and 75 was the liability. So the security and other things was very much into existence. But after passage of time, maybe because of losses, maybe because of diversions, but I feel that even bankers are equally responsible. But the IBC mechanism says that in COC, the bankers will be there because they are the secured one. And therefore, there is a second treatment to the operational creditor in spite of their no mistake. They have to forego their hard-earned money and get only a minimum 5%, 6%. While the bankers, who I can say that they were also part of the downfall of the corporate debtor, they are of course taking whatever best is available to them. So I think there needs to be some thinking on the topic which I was saying, that bankers should also be made accountable. They should also be made penalized for the action they have not. Because I have seen in one case with this 75-25 model, later on it was seen that about if 75 crore was the loan granted by the bank, every year the corporate debtor is required to submit their final accounts to the banker. They are expected that they will go through the balance sheets, understand. In one of my case, a cooperative bank in Mumbai, they were said that we are the sole lender to this particular company. And to my surprise, it came to my notice that this 75 which they were talking about, there were unsecured financial creditors to the tune of 300 crores. Now, I explained the banker, and I always keep on discussing this matter with various bankers, that it is your duty to monitor your client or industry and see that you are not turning into a minority. Because at that time when the COC claims were submitted, so naturally the financial creditors, even though they may be unsecured, but they will be hijacking your COC and controlling rather the COC. So they should have immediately objected when the unsecured financial loans were obtained by the corporate debtor. But such type of mistakes are happening. And when it comes to the IBC, and when they realize that they have hardly got a voting percentage of 22%, then they cannot do anything. But there are cases wherein such things have happened. Might be after the implementation of 2016, because see, businesses and businessmen, they are very fast reactors. They understand the law in much better way, and they might start doing planning to come out of the situation, and which the situation which I explained right now, there is every possibility we will be going to see another case wherein some fictitious financial creditor was there, and the NCLT falled heavily on that. But let us go back to where we were discussing. In between, I will tell you some cases out of my own experience. So these were the problems which were faced by the operational creditors, which are still not resolved. Haircut to lenders remain extremely high. So 80%, 90%, that is what I was telling, that up to this stage, what was the entire ecosystem was doing, particularly the banks. They didn't knew that there is a depletion in the value of asset. They have to review their security. They have to review their valuations. Almost every 3 years they are doing. But in such case, there should not be such huge amount of haircuts. So this raises questions about the effectiveness of IBC as a value maximization tool. Pre-admission delays, shrinking enterprise value, and promoter siphoning before CIRP. Because once you serve a notice upon the corporate debtor, in one of my case which was allotted, I have seen that when I went there for taking custody, the entire machinery was there into existence as such, but the key parts of the machinery, I noticed that it was removed. Now the problem is, if a financial creditor issues notice, if the assets are under the security, if the financial creditor has taken possession, then it's okay. But otherwise, in my case, the custody of the unit was lying with the local authority having sealed their premises. So local authority, if the custody of the unit is there, it is quite possible for the promoter or the director to remove the key parts before the case is being admitted. Because in my case, I have made a specific note while taking the custody that the key elements were removed from the site of the machinery. So promoter siphoning before CIRP is quite possible. And as such, we cannot derive a maximum haircut, but probably 96% what I remember was the maximum haircut which was taken, and haircuts are exceeding 70% also in the recent years. So this steep reduction is often due to factors like severe value erosion by the time a case reaches to resolution stage and lengthy delays in the process. But again, as I say, that what has happened is, since the implementation of IBC in 2016 or 17, what has happened is, whatever cases were there with RBI and other banks, means other banks, they are in the earlier BIFR. So they were immediately taken to IBC. So there were there was a flood of cases and which was required to be dealt. Now, after 7, 8 years, what has happened is the bankers have also understood IBC with their own experience. And now, as the provision provides that immediately after the default, the action can be initiated. So now there won't be so much of delay in taking the corporate data to IBC, and in next 7 or 8 years, probably we will find that there is a upward revision in the realizations, and the haircut is expected to be reduced. So pre-admission delays are significant despite of the statutory requirement. So see, all these 14 days and other things, those are merely academic, because now we see that almost in every case, when we are filing it online, so immediately a list of requirement comes. Every registry has their own set of rules. So there is no standardization in the process of various registries of various NCLT benches. And now it has been made mandatory that they are to be addressed within 7 days. Otherwise, many a times it requires resubmission. There is another thing which is not uniformly followed is, in case of Section 9 applications, many of the registry are insisting for the NESL data to prove the default. Now, NESL is a separate area where we have to assist in case of Section 9 application, that the registration has to be done by the supplier on the NECL website. So there are problems relating to the registration. There are problems relating to submission of documents to NECL. Subsequently, for giving 3 times opportunity, another 3 weeks at least are spent. And subsequent to that, the default is certified by NECL, as we can say. So many times this is being insisted by the registry office, and that is why there is a pre-admission delay many times. So statutory timeline is different, and in reality, the things are different. In a survey which was conducted by IBBI in 2021, it was observed that the average time taken was approximately 133 days. In some instances, this period has extended to 6 months or more. I can say confidently that in case of NCLT at Mumbai bench, probably we are not able to get the admission almost within a year. At least a year's time is spent. So because of this impact of delay is like erosion in the asset value, siphoning of assets, as I have discussed right now. And there is increased litigation. Delays often lead to more litigation, with parties appealing to NCLAT to expedite the matter. Now, this is also another problem, because what I feel normally is the benches should take, or a government should take some decision wherein, if it is observed that IBC process is intentionally obstructed, particularly by the promoters or the corporate debtors, means the suspended directors, because in many cases they are the first line obstructor, and obviously there is a reason for obstruction. But there are about 100 of cases in last 5 years where NCLAT has stayed the admission with continued moratorium, and before formation of COC, and the practices, the applicant after admission immediately approaches NCLAT. Now it is up to them also to see that if it was a frivolous application, then if the bench starts penalizing, then at least this frivolous application will come down. So basically, due to this, the lengthy timelines can discourage lenders from using the IBC process and drive them towards pre-NCLT settlements. So there are different views, and the concerned may get frustrated due to huge amount of litigation. So as we have seen that the primary cause of delay is inadequate NCLT capacity and litigation tactics by promoters, procedural issues, and lack of infrastructure. Because yesterday evening itself, while I was attending a case online with NCLT bench, they were in a hurry to conclude the bench because the bench member murmured actually that we are not assisted by any stenos or like that, and we have to complete our work, prepare the orders. So that is how the infrastructural arrangement which is existing for the NCLT members is also not adequate, because basically, according to me, they should be having a good amount of qualified assistant staff to help them in all the process. But since I am not an advocate, I don't know how the procedures are taking place, because the entire litigation process was observed by me only after 2017, because earlier, being a chartered accountant, I was not required to go or attend any as such court or tribunal. Next is excessive litigation at every stage. As I said, admission, immediately they go to NCLAT, obtain the stay. COC formation, immediately there may be issues relating to the voting percentage or the claims admitted or the members of COC among themselves. Then valuation is another big area where at times COC, at times promoters go for litigation. So confidentiality, challenge to 29A, plan approval, distribution of waterfall mechanism, all you will find that there were lot number of cases involving litigations. And as I said, that promoter often use litigation as a delay tactic. They want to frustrate you. Excess litigation primarily refers to strategic lawsuits, malicious filings, and prolonged legal battles that exploit legal provisions to delay the insolvency process, evade debt, or secure undue advantage rather than achieving genuine resolution. You will find many cases in the beginning years particularly in Section 9 applications, where the pre-existing dispute was tried to be fabricated by the corporate debtor. So even if it is not genuine, it is the bench is bound to go through the dispute and ascertain and decide whether the dispute is real or fictitious. So all these things, they are reducing the speed of the IBC. Yes, the related things have been discussed. So courts, including the Supreme Court in case like Mobilox Innovation and Kurosawa Software, has scrutinized the nature of dispute, ensuring it is plausible, not a spurious contention. The 2002 judgment in Rajaram Babulal Agrawal further refined the standard for what constitutes a valid pre-existing dispute. So friends, I remember that initially what has happened is the way people were doing businesses were totally different. But in the initial period, when after IBC came into existence, I started discussing with various companies rather that it is very much essential that everything should be properly documented. पहले कई बार फोन पे हो जाता था काम because of trust element which is there in the Indian economy scenario. So many of the businesses earlier used to be run on the basis of trust. Now trust cannot be proved in the court of law. So even now the companies which want to make a Section 9 application against another company, and not only company, even the individual partnership who are entitled to make an application under Section 9. I am telling them at various forums right since 2017 that you need to change the way you were doing the businesses earlier. There should be proper supply agreement or the purchase order or the sale agreement, whatever. The rates are to be decided, the quantity is to be decided, it should be documented, it should be signed. There is a special mention about whether you have to, you are agreeable for 12, 24%, 18%, 15% rate of interest in case if the amount is not paid within 60 days time, 90 days time, and whatever the case may be. So what is important is the document should be proper. In one of my case, when I went to the industrial area at Mumbai, that promoter was a very genuine person against whom the Section 9 application was made by a supplier. He said that basically he was doing the castings for the rubber manufacturers, rather tire manufacturers. So they require various type of castings. So when a certain material was purchased by this company, it was supplied as defective. But then I said that why didn't you took it on record before you received Section 8 notice? Immediately after receipt of material, you should have at least sent a mail that your material that has been supplied is defective. It is not as per the agreement. So later on, it has been clearly mentioned that later on you cannot raise any defects. And that was the reason many industries also suffered in that Section 9, because basically at that time it was taken as a recovery tool, and in many cases bench has protected the business which was running smoothly by way of not admitting them. So next is the fraudulent or malicious intention of CIRP. This was the case that IBC includes provision section 65 to penalize parties who initiate insolvency proceeding with the intent to defraud creditors or for any malicious purpose. The best example is Videogon Infinity Infotech Parks Limited versus Electroparts India Private Limited. So Electroparts India was a fabricated creditor, and they have entered into documents in order to manipulate the process. That was a very interesting case, and therefore NCLT Kolkata bench, they took a decision that they imposed a penalty of 50 lakhs and directed the ministry MCA to investigate the matter comprehensively. So what we were looking was that there are litigations at every stage, and this is also one of the reasons. I think the litigation portion I have covered. Now let us go to the prolonged challenges to the resolution plan and valuation. Friends, shall we take a 5 minutes coffee break? Yes, please.
Yes, sir, we can take 5 minutes.
Within 5 minutes, I will come back. Be there. I will immediately start. I have something interesting to tell you about that.
Yes, sir.
पानी भरून. So shall we resume?
Yes, sir.
Yeah, thank you. So basically, I was discussing about the prolonged challenges that are there in the resolution plan, because as we have seen in case of Bhushan Power and Steel, after so many years, the case was reopened. Even the plan was implemented. It was opened due to legal changes. And then the watershed decision of Supreme Court came on 2nd May 2025, because of which the entire ecosystem was surprised to see such a decision. But it was a well-informed, well-reasoned order. But subsequently, the corrective review measure were taken, and we all know about that. But actually, if such thing happens, it shakes the confidence of the investors, because in case of Bhushan Power and Steel, the JSW has given a plan of about 19,000 crores. So it was a huge case. Another reason is the jurisdictional battles and the interface of other laws, because disputes have arisen in the intersection of IBC with another statutes, leading to multiple parallel legal proceedings. So PMLA, they have their own mechanism. Similarly, CCI also has their own mechanism or procedures. So even if the IBC law is overriding, there is a problem between the other statutes. And because of that, some time is wasted. So conflicting orders from NCLT and PML authorities regarding the asset attachment have resulted in significant litigation challenging the clean state principle of the IBC. Because IBC, what it says, that the resolution applicant, in case of CIRP, or a bidder, successful bidder, in case of a liquidation process, will get a clean slate to start the activity from the date from which he has made the payment and the payment is completed. So he is not bothered about the earlier problems. But such things, if it happens, that is what I say, that it disturbs the confidence of the investors. Again, there are contractual disputes. So there is an ongoing debate regarding the extent to which NCLT and NCLAT have jurisdiction, because in case of JSW and Bhushan Steel, the Supreme Court has fallen heavily on NCLT and NCLAT, even about the area where they should not have taken any legal decision which was out of their jurisdiction, particularly NCLAT. So there is a problem with the jurisdictional area and the contractual disputes. So nowadays it is seen that many a times while approving the resolution plan, the bench is very much clear that for the concessions which have been asked, they are not granting anything on that, and stating that if it is relating to income tax, the concerned department will deal as per the law applicable, and that is how they are not going to comment on it if it is for any other laws. Actually, this has a recent problem of competition, that is CCI. In one of the judgments given by the Supreme Court, it addressed the whether CCI approval is mandatory before a resolution plan. So now, if such thing goes on happening, it will further add time and become the process difficult. Now, next problem which is persisting is Section 29A challenges remain contentious. So determining ineligibility of resolution applicant consumes time. See, basically, an RP or a liquidator is required to at least primarily verify the ineligibility of the applicant. Now, with the help of AI, like ChatGPT and many other, and with the help of Google, we are able to at least trace, even though we are taking services of outside agency who are expert in giving their eligibility report under Section 29A. What I primarily feel is we can also conduct a small survey with the help of providing data to the ChatGPT or Google or many other such forums, wherein we can get some information, and this 29A challenge can be met. So connected persons, NPA status, related party, even in case of JSW, it was observed that they are into a JV at some mines in Odisha, where JSW and Bhushan Power are connected, and that way 29A ineligibility is there with JSW. Genuine bidders sometimes discouraged due to fear of later disqualification. So key judgments in 29A are the ArcelorMittal, because it spoke about the control, management and related party, and which led to multiple layers of factual analysis, but it caused more delay. Swiss Ribbon is another case, and Onyx ARC, it actually expanded the interpretation of the related party ineligibility. So 29A remains one of the most litigated provisions. Eligibility challenges sometimes run for 6 to 12 months, discouraging the genuine bidders. Another problem is poor quality of information at the commencement. Information memorandum often incomplete or delayed. Books of accounts often unavailable or manipulated. lack of cooperation from suspended management despite Section 19. There are about more than 125 cases that have been decided till the date on non-cooperation. See, basically, many of you might have come across such type of non-cooperation from the management. It is not a new thing. Basically, in my first case, when I went along with the suspended director for taking custody of unit, it was in an area which was classified as the Naxalite area in Maharashtra. But I went, even though it was my first case, I went with proper preparation. Like I had a couple of my team members to assist me. Luckily, a person from the ARC who was applicant and was a CSE member was also there. Before going for taking custody of the unit, what I did was I appointed the security agency immediately and asked them that at least a dozen of security personnel properly dressed should be there at the site because I require for all the 3 shifts. And I hired another videographer, professional videographer, that while taking the custody, he should be there and he should take all the video recording. Because it was my first assignment, I was very much careful about the things. So what has happened is the suspended director happily came along with me in my car. The thing was, it had a local authority custody attachment by the chief officer of the Nagar Parishad. And it was the premises were locked, the factory gate was locked. So after reaching there, when I explained to the chief officer of that small town, naturally he was unable to believe in any of the things. Then along with some governing board members of that Nagar Parishad, for 1 or 2 hours, I explained that this is the order. I have been appointed. I should be treated as a court officer for this purpose. And I have that letter obtained from IBBI that for any assignment, the concerned IRP or RP is treated as a court officer. So I tried to explain them that you are not listening to the order. You are not listening to the court officer. So ultimately, they realized that they should hand over the custody. And at about 3 p.m., so as he was there present along with me, the suspended director, he all of a sudden become uncomfortable because what he was feeling is the chief officer will never give the custody. And that is why he started sending somebody to the local court for obtaining any stay for taking me the custody, but nothing of that sort happened. And when I took him to the factory gate, he immediately sat outside the factory gate and said that I am not going to come inside. So I ordered that videographer to start the video from him itself. And then we took the custody. I asked the videographer to be present at all the places. We prepared a panchanama. We prepared the entire layout as such by way of a hand drawing, and took the custody and took the signature of all the present over there as panchanama and handed over that to the security agency. So that is how, while taking custody, we can take care. And there, what I was telling you earlier was, I have taken a note in that panchanama that key elements of the machinery was observed to be removed. So information memorandum, it becomes difficult many a times because of want of information. And friends, even though we have section 19, as I told you, for making, preparing, drafting, filing, getting it approved, getting it numbered, there are so many hurdles. And the 180 days time we have to chase and follow. So it becomes very difficult. So if the situation of section 19 doesn't come, it is better. And in spite of that, section 19, the suspended director may tell any reason that the data was lost, data was crashed. So if they want to not give you the data, you will not get the data and you have to proceed on the same basis. So key judgments of poor information at commencement is Alok Industries, Mozarbeer case, where there was a repeated non-compliance. You can read the case, very interesting. But even big cases, they are doing it that way. Shailesh Sangani. So IP still struggle to obtain the books data. This directly delays the information memorandum valuation and plan preparation. So many times if the system is in SAP, the SAP, due to non-payment of charges, the SAP is not operational. Many times if the Google workspace is there, so all the linked email IDs, you will not be able to see because the Google payments are not made. So they will put hold that. So again, if it is a mandatory requirement, you will have to prove it under that moratorium under essential services, whether you require that Google workspace to start as an essential services. So it is very difficult, but the provision is there. Next is difficulty in attracting quality resolution applicants. So many sectors have limited buyers, in the sense that I was dealing with one company who was a service provider in a huge steel units. Now, what was their work? Their work was to remove the slag which was coming out at the end of the entire steel production process. So from that slag, which was like a liquid at 1500 degrees centigrade or more, the slag has to be cooled down. So they used to pour continuous water also on that. Similarly, it has to be broken in various pieces. Their job was also to take out the remaining particles of ions by way of magnet using heavy duty magnets. So even 3 to 4% iron was collected from that waste, and subsequently that waste, when broken into pieces, like the stone crusher unit, they have that facility also. It has to be sent to a designated place where almost a mountain was made out of that slag. But the important thing is, this is a very specialized type of job to handle the hivas and other things. And in that case, there were no much proposal or buyer. Then fear of future litigation or promoter challenges discourages new buyers. So we have seen that there are many litigating promoters. So now the investor might feel that who is going to face, even though it is a frivolous litigation, it has to be attended. No, you yourself cannot decide. It is the bench to decide that this is a frivolous application. And funding constraint for ARC and stress assets investors. So these are some difficulties which are there in attracting a resolution plan. Then insolvency professional face constraints because we have limited authority to take action against non-cooperative promoters. No protection is there for personal liability. So resource constraint, IRP may not have manpower for large and complex data. So basically, this problem is there, but we can overcome this problem because when I started working in 2017, there were calls received by me with many big four firms asking me whether I am interested in joining. So I initially thought that I should not join because the problem is the IBC particularly takes you as the responsible being IRP or RP. So even though you might be helped by a team of 10% or 100%, the accountability is solely with you. Now to handle situations like big companies like this Bhushan Steel or Jet Airways or Kingfisher, even though you might get a team of 70, 100%, but even their work, we are accountable, we have to see. So I chose that at that time that I should handle that much work which I can handle along with my existing team. So resource constraint, if they are there, we should see that what type of corporate data we are giving consent to. And if we are able to handle, we can give our consent. Then valuation challenges are there. Valuation in distressed are highly subjective. Now see, in infrastructure project, I have got two valuations for ranging around 200 crores or 300 crores. I don't remember the exact amount. But later on, those promoters, because of the litigation and other matters, those valuers gave me a written email that they are withdrawing their report. So next set of valuers were appointed, and again that 200 crores valuation, the new set valued it at 90 crores. So I don't know which one is correct or which one is not. Another case which I was dealing, in that case, the valuer, what he has done is, he has valued the factory building more than its historical book value. So naturally, there was a huge gap between valuation of two valuers. Normally, the policy which I have adopted is, I appoint the valuer, I give them all the comfort data which is available with me, and I normally don't even ask for a draft report also from them because they are professional, they are IBBI appointed valuer, and I am not going to ask them to increase the valuation or decrease the valuation because it is none of my business. Even I do not permit the COC to communicate with them because their decision should be independent, it should not be influenced. So particularly in case of valuers, I take care that COC will not influence or communicate, and neither I will do anything which will influence their valuation. But after getting the report, when I discussed with him, he said, no, the steel value has gone up, then the cement value has gone up. Well, that is how we are valuing things. A historical, we are valuing building more than the historical value. So it was really surprising for me. Then I have to appoint the third valuer, and I did the work ahead. But these are the valuation challenges. Next is, in case of quality of valuation, there are frequent disputes which are reflected in the key judgments of RP of Jet Airways. So court intervened due to valuation differences and expert disputes. Even in case of Bhushan Steel, there were multiple valuation challenges. So this is a persistent problem that different valuers often give wide varying numbers COC decisions are attacked on the valuation ground, resulting into appeals. In one of my case also, what has happened is the liquidation value has fallen down drastically, maybe almost by 40% at least I can say, because it was relating to the valuation of a hospital in which the key machineries like the MRI and other big machineries, they require the AC is to be on all the 24 hours. But with the passage of time and with no cash flow in hand, and since the CRP was getting extended, after a few months, the electric company had no choice other than to stop the supply. And naturally, I also could not do anything. And because that helium and other gases were gone, and there due to non-maintenance, that hospital also got a bit devalued. So there was a drastic fall in the value when I went for the CRP, rather the resolution plan. Now we go to the next.
So can I ask a question here, sir?
Yeah, always.
Sir, what happened then? So let's say your resolution plan assumed a value of, let's say, 100 crores of the apparatus in the hospital. Then the value was, let's say, 10 crores after 2-3 years. Then what happened was, I mean, in your experience, because of the depreciation, the liquidation value, was the plan revised, and how did you proceed with it actually?
See, basically, yeah, that was the next part which I could have told earlier. That this because of depletion in the value of asset, which the COC, there were two members of COC. One was having 75% voting, another was having, let us say, 25% voting share. What happened was when the resolution plan was put to vote, they could realize that if the 25% descends, then as per the liquidation value norm, even though the liquidation value has eroded, on record, it is more, and therefore the dissenting creditor is going to get more. So that created a problem between the two COC members. Then that is why the things were delayed. Then they thought of taking another valuation. But basically, there was no reason for me to take another valuation as per the provisions. So they decided to vote it in favor, because ultimately they could also realize that the plan which they have received is a reasonable plan, looking at the present liquidation value which they might have worked out from their own resources. And due to that, again, the confidence of the COC member having 75% was not there. So I said them, better instead of electronic voting in the COC meeting, both of you sit together, take the printout of the sheet and sign it in front of both of them. So that is how it was resolved, because had the minor share dissented, then he would have been benefited. But they made some arrangement and they did the physical voting, and that is how the thing was concluded.
Right, sir. So can I ask also one follow-up question?
Sure, no issue.
So this was, sir, in a case where the value got depreciated. In certain cases, especially the real estate companies, the value gets appreciated due to the passage of time. So as you noted that in many CRPC, especially home buyers, they have been in the NCLT for 6-7 years. So initially what happens is that in many such CRPs, only the home buyer is the part of the COC, which is the AR who represents the COC. In many cases, the valuation is taken, let's say, of 2020, and now today it is 2025 or almost 26. The COC approved the resolution plan, but it was never approved by the adjudicating authority. So now the situation is that there is no approved resolution plan by the AA. but there is a resolution approved by the COC, but the valuation has gone 5x of the assets. So the whole objective of the of IBC is to maximize the value. But here, if the plan is implemented, then ultimately the creditors or the home buyers will get 1x of the value. So how do we reconcile this situation with the law and the overall objective of the IBC in your experience, sir?
Basically, if the adjudicating authority has not approved the plan, and basically there are few cases in which, for the sake of improvement in the value, if such thing has happened, at times the bench has asked for resubmission and giving equal chance to all other who were there in the initial round. And if they can, because value maximization is the objective, so it is quite possible that another round of submission be prayed in front of the bench because of the facts that has changed the circumstances. But at that time, not only the one who has got the approved resolution plan, but if there were 5 other RAs, they will also be given equal chance to once again revise their resolution plan. That is what the present case is.
Thank you. Very helpful, sir. Thank you, sir.
See, in one of my case which I was doing, it was a landmark judgment given by NCLAT. In this also, the same point was pleaded. It was a company in liquidation wherein the land was sold, and due to litigation, it was held for a period of 5 years. Now, naturally, the applicant who was promoter, who was opposing this sale, said that in this 5 years time, the land value has gone this and that. And basically, the thing is, even if the ready reckoner value or the stamp duty valuation at many places is considered to be fair, High Court have taken a decision that whenever a particular land is valued by way of some official mechanism which is followed under a law, that will be treated as the final market value of that property. And merely because 5 years litigation might have increased the value of land is not the reason to again change it, who has come with the following the due process of law. So we have to think it in that way, because if it happens the other way around, like if the land value has increased because of this some development, a road has approached near to the land, or some airport has been planned near to the land. Like in Mumbai, it is now the Panvel Airport. But if government takes a decision that at not that place, but it will be taken at some other place. If the road was supposed to be constructed at the time the valuation was made, let us say like we have Samruddhi Highway in between Nagpur and Mumbai. So these type of developments do appreciate the value of land. And in that case, if some government decision changes, then there is a devaluation also in land. You might have purchased it at 100 rupees in anticipation of the government development. And if something changes, it may be valued at 50 or 40 also. So that is why upward, downward changes are normally not dealt with the benches. That is what I have seen.
I agree to this, sir. Can I intervene here?
Yeah.
Sir, what the other person who has raised the question, he is seeing it from one point only, that in last 4 or 5 years the value has increased, so why not to take benefit of that now? What happens if the value is decreased? The resolution applicant is bound by the resolution plan, even if there is a delay in the approval of resolution. If he is bound by the resolution plan and it is a delay because of the judiciary, what is his wrong? What does he has done anything wrong? So I don't think there is any possibility of giving any decision that once the plan is approved by COC, it is binding on COC, it is binding on resolution applicant.
Absolutely.
Subject to approval of NCLT. And if NCLT is delaying the approval, that is not the means, and NCLT cannot enter into the commercial wisdom.
You are absolutely right.
Even if COC wants to reverse his decision, they cannot reverse it.
See, basically, what has happened is if there are few cases, exceptional cases, wherein some other views have been taken by NCT, but by and large, what you are saying is absolutely correct, and it is binding on all. So we should be clear, because if it happens the other way around, so the RA is not permitted to reduce the value. That also needs to be considered. So shall I move forward? Yeah. So we have discussed about this. And real estate complexity. So the cases are that home buyers as financial predators create logistical complexity, because the representation is also very important, that who is representing home buyers, and multiple projects under one company. Determining the project level CRP is unclear, because if there are 3-4 projects, then how the assets and liabilities are to be ascertained is another big question. But with this recent amendment, which is applicable for all the industries across, recently I have got a plan approved in which my company was having 3 units, and 1 unit and the company is going into liquidation, while other 2 units we have got a resolution plan. But for this also, since this was the one of the rare situation, it took time for the bench to understand. They have asked for various judgment, and my counsel has provided various judgment, but the provision exists. So what I did in that case was, these 3 units were geographically distributed in different states. So as far as the claims were concerned, I tried to segregate it with the help of related unit, and there were certain common claims, like in case of excise or customs, which was associated with the machinery. So that was distributed on the basis of machinery. But as I said, that determining the assets and liabilities particularly and dividing the claims, there is no clear-cut guideline as to how we should do. Everybody is doing from their best possible logical estimates. And I also did it in the same way, that all the units, assets were segregated, liabilities in the form of claims I divided amongst the unit and tried to complete, and I got the approval of the adjudicating authority also. So interplay with RERA also is causing overlapping jurisdiction and delays. RERA is another problem with IBC. So key judgments I have taken out is the Pioneer Urban Land versus Union of India, where they were flagged with administrative challenges, because home buyer is a scattered group. Amrapali group was a famous case. In that case particularly, the court was monitoring the project, because at that time the things were totally new. Supertech is another case I have mentioned. I will provide you with this PPT presentation so that you can go in detail, the one who is interested. And this multi-project entities create issues in claim segregation, as I told you right now, that how the claims are to be segregated. In case of this real estate also, if we have, let us say, 3 different projects in 3 different parts of Mumbai, then the steel is purchased in totality, cement is purchased in totality, liabilities are created. So there may be certain liabilities which are project specific, but there may be certain liabilities. So we have to find out the basis for which as such no guidance note is available. But on the logics, we have to segregate the claims, and then we have to run the project by CRP, home buyer representation, and funding for completion, and no codified solution is available. So these are the problems which are persisting. I have personally not done any real estate case, but I have assisted in one of my friend's case who was dealing with real estate. Now, when the claim starts coming in the first month, it is a huge amount of claim, and since it is relating to the home buyer, we have what we used to do is we used to prepare a Excel and stating that on which date the claim was received, who is the claimant, what was the claim. So all the details, including KYC and other documents. So this, how much is the amount paid, how much is the interest claimed, and all other things, which flat was allotted. तो वो पूरे डिटेल्स हम उसको एक्सेल फॉर्म में बना के रखते थे. And then the communication was required to be made with the home buyers that before admission of the claim, ये document submit नहीं किया. म्हणजे if some deficiency in submission of documents, and we used to ask the office that write the date on which we have sent them the email asking for further documents, and if they don't respond, then their claim could not be admitted for want of proper data. So everyone is following their own way of dealing with the ascertainment of claim. Then coming next is the group insolvency. It is not yet institutionalized. So no statutory mechanism for group level resolution, joint COC, then consolidation of assets and liabilities. Courts do handle it by case-to-case basis, leading to inconsistent outcomes. The next is liquidation continues to outnumber successful resolution. So over 70% of the admitted cases end into liquidation. This is the very sad part of it. But I believe that this will come down because these cases are all old cases in which the resolution value left is very less and it was only required to be liquidated. Assets often sell as scrap value, the objective of resolution over liquidation, not consistently achieved. Then section 66, actions are underutilized. Very few recovery actions against errant promoters. IP face difficulty gathering proof. Long duration and low success rate discourage such actions. In one of my case, I came across the write-off of stock and write-off of debtors just before the admission of the order. Entire debtors were written off, entire stock was written off. So it was a paper industry. So it is a clear-cut case of fraud. But basically, we know as a professional that many a times the stock is inflated and shown it in the books for the purpose of obtaining the drawing power. But again, in terms of the definition of fraud, it is a fraud committed by the suspended directors, you can say. So when I personally asked him about the debtors, that whether I can take the recovery, the debtors were approximately 3 to 4 crores. He said, sir, basically 3-4-5 साल जो घर चलाया है वो ये डेटर से पैसा लेके चलाया है. That he can tell me in person, but he cannot tell me in front of the bench, no. So I have taken it as a fraud for debtors also and for stock write-off also. Then next problem is liquidation continues to outnumber successful, that we have seen, and section 66, yes. Cross-border, I have discussed a bit at the beginning. See, the United Nations Commission on International Trade Law developed the model law on cross-border insolvency in 1997 to provide a universally applicable framework for dealing with cross-border insolvency. हमारे corporate debtors का property, if it is there in the different countries, or other countries corporate debtor are having assets in India, it deals with that type of situation. So there is no clear legal framework on the and statutory. So IBC do not provide adequate, specific or comprehensive provision for handling cross-border insolvencies, while section 234 and 235 allow for reciprocal arrangement with foreign countries for matters related to insolvency. So these are contingent upon the bilateral treaties and notification. So there are jurisdictional conflicts and uncertainty, and there are difficulty in coordination and cooperation among the court. So it is altogether a different scenario in case of cross-border and inadequate treatment and protection of foreign creditors, issues related to asset recognition and enforcement. Because now we know that in case of information memorandum, we have to give them the geographical coordinates also of the assets. So while ascertaining the assets of the corporate debtors which are situated outside India, it becomes very difficult to provide with the asset recognition outside India. And in case of Jet Airways and Kingfisher, which had an international operation, leased aircraft from foreign leasers, and had financial dealings across border. So issues ranged from return of aircraft to foreign lessors, and recognition of foreign creditors' claims. So naturally, IBC does not deal with the assets that are not owned by the corporate debtor. We very well know that. So these type of problems come up more particularly in cross-border insolvency. If you look at the last point, as far as the persisting problem, which I have understood, there may be more problems, but I have shortlisted these many problems, is the lack of pre-pack effectiveness for MSME. So total cases admitted as of September 23, because that was the last data which was available. So only 6 applications for PPIRP have been admitted by the NCLT. Out of the admitted cases, only a single case, that of GCCL infrastructure and projects, was initially resolved through PPIRP model process, and other sources mention 3 cases resolved by September 23, with the remaining pending or withdrawn. So basically, that indicates that PPIRP has not gained much popularity. So friends, till now what we have seen is what were the problems in the initial years that were overcome by way of amendment. Then subsequently, I tried to discuss certain problems which are still persisting and cannot be resolved in totality. Now, I have tried to come with certain problems which we as insolvency professionals are facing, that partly I have discussed it earlier, but lack of cooperation from the suspended management is the major problems. And if they do not provide you proper bank credential, because in one of my case, and yes, another problem is not only with the suspended management, but you might agree, many of you might agree, that in the initial years, 17, 18, 19, we faced problem with the bankers. We used to show them that we have been appointed and you need to put our name as authorized signatory, put our sign, scan, take our KYC. But at the branch level, it was never attended in a proper way. And they used to ask for resolution because they used to do their banking in their own way. So that were the initial problems with the bankers. Now I am dealing with one of the company which is in liquidation. I have opened a liquidation account, and after completion for filing dissolution, I have closed the bank account also. But there existed another bank account, 2 bank accounts, one with a private bank and one with a nationalized bank. So for nationalized bank, I got a response immediately after a day or so. But in a private bank, Yet I have not received any response. I was asking them for closure of the account, which already had a zero balance right from 2017. But they say that they have what you call as lien on the account, which is there by some income tax department or so and so. So it is really very difficult for us to explain that all these government departments have submitted claim to us. I have also, particularly in this case, luckily there were no financial creditors. And when I made a contact with the commissioner there for providing, because in the claim they have not submitted me the proper bank account where the money should be sent. So he was very much surprised that you are paying us the money because I am having a 7-8 liquidation, and they are prepared for that. They are not going to get a single rupee. So it was that is why they normally don't give any particular that where the money is to be sent, because they know that they are not going to get any money. So anyways, so that is a lack of cooperation not only from the suspended management but many times the bankers. And that is what a problem we are facing. Then delay in information from government authorities. So verification of claims from PF, excise, GST, income tax take months, and ROC records many times it is not updated for 3 to 4 years. That is another difficulty. Litigation with statutory authorities continues despite moratorium, because what they do nowadays, earlier I have seen in case of a Karnataka bench, they have penalized the GST officer individually by sum of 50,000 rupees for not following the moratorium. But now these government departments have also understood IBC. But the thing is, there is a constant request by PF or GST for conduct of audit of some earlier periods prior to CIRP. अब इसमें ऐसा है, हम नहीं भी नहीं बोल सकते और हाउ भी नहीं बोल सकते, because many times we don't have the data available for the earlier years. So in that situation, it becomes very difficult because employees might have left the organization, the data might have kept in the computers. So even if I am willing to give the data, it becomes difficult. So they naturally go to the bench against me. And I also tell the bench that how can I give the data for even audit? And by that time, the case comes for hearing. It becomes a frivolous application right by that time. So that is another issue. Next is controlling and protecting company assets. Now, as I told you that in one of my colleague case, what has happened is I have to appoint the security agency anyhow after taking the custody. But in that case, after the COC was constituted, the next day, the promoter could succeed in getting stay for the process. Now, the matter is going since about a year. Now, the position of the IRP is he has taken the custody. The COC stands constituted. Immediately on the next day of the constitution of COC, the COC constitution application was filed with the bench. It was taken on record. So everything was over. Now, since that time till date, who is going to pay me the security agency charges? And the security agency is always saying that, sir, for 8 months, 9 months, you are not paying single rupee. So in that scenario, it becomes difficult to protect the assets of the company. Then assets missing or encumbered without proper documents. This is another problem, because how do we identify that? And difficulty in taking physical possession of the multiple properties. In one of my friend's case in Ahmedabad, he came across a corporate debtor where he was having assets in Nagpur, in Diu and Daman, in Uttar Pradesh, near in some place at Gujarat, and one place away from Nagpur at about 50 kilometers in a rural area where he had a textile unit, running textile unit. So now these are the problems that if we have to take the physical custody, and normally from the decisions taken by IPPI in disciplinary cases, it is seen that there are certain key areas which are expected to be done only by the IRP. So taking custody is one of those acts. So we have to be there and we have to take the custody. Litigation overload. I can tell you the first case which I was referring, it was admitted in the year 2018. And I was IRP, subsequently I was RP, and subsequently I was liquidator because at that time it was permitted. Various litigations everywhere, it came in our favor. But see how many years have passed, almost 7 years. And the errant promoter, you cannot imagine, made 12 complaints against me with IBBI, 3 complaints with my IPA. Everywhere I came out clean because they were frivolous complaints. But he keeps on torturing, he keeps on discouraging me. And therefore, even as of today, about 3 to 4 mails are being sent. And his style of working is he will send copy to at least some 23, 24 ministry, MCA, PM office, CM office, everywhere. Everywhere it is possible. So now what as an IP we can do? I have done is for his email, I have prepared a separate folder which will not affect my routine email account. And whenever time, nowadays, after 18, recently he has learned getting answers from ChatGPT. So he puts on the situation, ChatGPT halfway understanding, gives some solution, he copies all that and put it in the form of email and send it to everyone. IBBI chairman, IBBI whole-time working director, IBBI grievances cell, everywhere. So in such a scenario, what we can do? We cannot do anything. So multiple cases at various level. Yes, I have gone in all these forum, including the Supreme Court.
Sir,
I
under
have
all this situation, there is a kind of stress that is put on us. And are you able to work normally after that?
no. Yeah, that is a good question. If we see our Prime Minister, how he is facing on a daily basis, then we are nobody because we are just to, I at least ensure that my documents are proper, my records are proper, my emails are proper, my wording is proper. And that is how, because of him, I was also required to face the disciplinary committee also. But that was also an experience for me. Luckily, I came out clean out of that with a small observations of delay in submission of progress report and so on. But the thing is, it is good that somebody is chasing you because that takes me to another level of perfection by maintaining proper records. So that is how there is a stress definitely. But if you keep
There is
your
a stress
records
and
proper,
there
then
is a, it feels like we are not resolution professional. It feels like we are compliance professionals, just complying
yeah,
with each and everything. That's
yeah,
it.
that is true. But basically, if you see that how many activities, I'm going to come to that also. So there I will elaborate it on that. So let us continue with the topic at here. That litigation overload is there. Moratorium is also frequently challenged and frequent appeals on admission, claim, classification, COC. So हमारे कांटेक्ट में जितने भी स्टेक होल्डर्स आते हैं, लाइक आई हैव बीन वेरी गुड टू COC, and at one point of time COC is also taking me against me. So all this is happening. We have to do is we have to be proper compliant and create records. Then next is managing operations of the company. Yes, this also I have faced. I have done the CIRP of a running company. It's a huge Herculean task because IP may not be operational expert in to manage vendors, employees, cash flow, compliance, and production. So if it is a going concern, naturally the statute says that you have to maintain it, the status as going concern in order to maintain the value of assets and maximizing the value of stakeholder. If it is only if it is running into losses, then you can stop the activity. Otherwise, you have to carry out the activity. In my case now, but it is becoming a bit easy because while raising the invoices, while making the salary payments, I can sit it at my place. I have made a maker checker type of facility with the existing employee. He verifies all the details, sends me on email, and once I'm satisfied, then the salary is released based on the attendance. The production reports are there. So you remember one thing, that if the unit is operating, then you will be assisted with the existing staff, and that is what is expected. So the problem is everyone, because see, in IP we have CA, we have CS, we have CMA, we have management expert for 15 years criteria you have. So who have gone expertise in management. We have also got lawyers. So now for each and every of them, it is not difficult. It is not easy to handle all these things. So this is another challenge I can say to the IP, and difficulty in getting the resolution plan. तो यहाँ पे COC हमारे से अपेक्षा करती है कि we should be a marketing expert in taking this for a resolution. But after the initial years, what has happened is we have got a very good investor data bank, which was naturally created, and we have got a very good asset bank also, those which are available for sale, I can say, under CRP or liquidation. So we can move the details after they are being published and try to get a good resolution plan. But investors are normally reluctant because of poor financial health, pending litigations, and regulatory actions which they might be filled. Unrealistic timeline under IBC, we have seen that they are rarely met. The delays are mainly, that also we have studied, that valuation, if it is given, then the data will be given, they will be asking, they will be visiting, they will be preparing. So valuation also may sometimes take a good number of days or months. So this may delay our process. Forensic audit also, they don't get sufficient details, and that is why their work is also stuck up. Litigation is the popular area, and claim verification, as I explained, takes a lot of time. If there are huge number of claims, we have to, हमको कॉन्ट्रैक्ट लेबर अपने ऑफिस के लिए अरेंज करना पड़ता है फॉर वेरिफिकेशन ऑफ क्लेम्स, एडिशनल स्टाफ. Then next is disputes in claim verification. So if we don't consider the interest, there may be dispute. If the unsupported documents are there, naturally many times we are not admitting the claim. Related party claims are there. Home buyer claims are there. So the entire claim area is full of difficulty, and disputes can arise out of that. Operational creditor pressure, because OCs often demand priority payment. difficulty in communicating waterfall mechanism under section 53. So, home buyers, yes. Then personal risk and liability is there. We are facing criminal complaints. So, suspended director may go to any extent. In one of my case also, he has gone to police making complaint against me. It was again a frivolous complaint. I normally do not do anything that it will affect anybody's interest. So they have never admitted that police department after I told them about that. But we have to face. There are threats from promoters, employees. Many of my other colleagues have faced that. Police issues during asset takeover. So heavy personal liability. See, we have a very good section 233 in IBC, wherein something which is done in normal course of business and in good faith, because we are the person sitting at there. So we can do anything based on our own experience, but it should be proper and it should be done in good faith. Then, as one of the participants was right now saying, that we are burdened with heavy compliance. IPPI, NCLT, COC, ROC, GST, ESI, PF, and I'm facing all these things because now what I was doing is, if the salary is made, I used to ask that accountant that send the salary sheet, first deposit the TDS on the very same day. First deposit the PF, complete the PF compliances, and then release the salary so that there won't be any lapse from my side, because once the payment is made, we get relieved कि यहाँ salary payment हो गया करके. So that is why I followed that. Even though we are permitted to file the TDS within next 7 days of the next month, I don't take the risk. I immediately pay the TDS and get it updated. Then monthly progress report, minutes. See, in this monthly progress report, because I am handling 2-3 liquidation cases, it is absolutely very penalizing for me. Because what happens is, earlier in 17, 18, 19, at that time we used to simply prepare the report, progress report, and send it across to the NCLT over email. That was the sufficient compliance. Now later on they prepared it like you have to file an IA. Now this IA activity is such that if an advocate is to be appointed, then the fees issue will come. Then there will be hearing. And as I told you that even for quarterly progress reports, the entire pain is to be taken like a submission of a new IA. So I think this monthly progress report system should be simplified, or the earlier system should be adopted if nothing special is happening during those 3 months. It is a very difficult task. Minutes within 48 hours, Sunday roya, Monday, Diwali roya, kuch bhi ho. So we have to take the meeting on such a day that we will be in a position to complete the minutes within 48 hours. And friends, we should try to see that we are really submitting the minutes within 48 days. We should not give chance, because nobody is going to see whether you have submitted in within 48 hours. It will only come to know when some matter comes in front of us. But better not take a chance. Public announcements are there, minutes are there. In case of one public announcement, the Katak bench has appointed me under section 9. And when I made the application advertisement in 3 days, I came to know the earlier case which I was telling, that unit was having, that company was having units in 3 different states. So immediately after making the first public announcement in the state where the registered officer was there, immediately the next day, I again made a public announcement in Karnataka and Odisha. So that is how we have to take decisions. We have to be very alert when the case is allotted. Fees issue is there. Many of them have discussed with me that there is a delay. So if there are no resources, COC or the SCC will never like to pay from their pockets. But I can give you certain tips. Like many times there is a fixed deposits and a bank guarantee, or for a pollution control board there is a bank guarantee and attached fixed deposits. Or many times in cooperative bank, the corporate debtor is having certain shares. Or many times there is a TDS which is to be, we can get a refund. So after having a review of the CD, we should keep one thing in mind, that the COC is not going to as such pay us the amount of CRP fee or liquidation fee. So we have to generate our own. So if there is, it is possible that the CD is having certain such funds which are blocked somewhere, we should try to release it, and then we can meet the CRP expenses. And valuation challenges we have discussed. Dealing with the workman and employee is another task, because they often trouble you of lockout, particularly. Strike and lockout is a different challenge. And naturally, the suspended management is there, non-cooperation is there at various level of employees and officers. And wage payment also, at times, if the money is not received, you have to postpone the payment, because of which the employees are dissatisfied. Incomplete or non-existent record, I have discussed. Forensic and transaction audit, these takes too much of time in identifying the. Okay, in this also I would like to tell that here what is expected in the court is, before we have to form our opinion based on the scrutiny of financial statements and accounts, that there may be a possibility of POFE transaction. So you have to put it in your record, mention it in your record, that after scrutiny you feel like these are the probable transactions, or these are the areas where you feel that there is some preferential or undervalued or fraudulent or extortionate. So the code requires you to prepare your own opinion, based on which you have to appoint. Even after appointment, simply by taking the report, you cannot rely. You have to take up the matter with the CD or the suspended director for obtaining their views, and then finalize the report, give them the chance of getting the explanation, and then you can, because that is what the bench has also stated in some of the cases, that the IP has not applied their mind. So in order to not to face that, we have to be careful. Valuation challenges are there, and dealing, yes. So I'm trying to sum up it as early as possible, because certainly I can answer some of your queries. That is more important. So now the forum is open for question answers. Is there anything in the chat which has been asked, and if anyone can help me so that I can answer the queries in chat if they are. Anjali madam, you are there?
There are no queries in the chat box.
Okay, we'll give them 5 minutes for thinking and asking questions. You can also ask them that if there are any questions to be discussed, I can explain it. I have kept a bit of. Basically, I would on my own discuss one point that recently one whole-time director of IBBI has visited our city, and I happened to have a sufficient time with him. So I told him that IBBI, fine, I am also a member and you are the regulator, but merely taking action on the member for the fault is not, it should not be the only objective of the regulator, but they should also ensure that the members should get more facilities and they should be proactive. Like we as a IP are trying to educate and explain about the code at various levels like banks, local authorities, electrical companies, and others, and MSME forums, explaining the provisions of law and regulation. I was expecting that IBBI also should coordinate with the uh, bank industry as a whole. So, association, the IBA, they can take Indian Bank Association. Similarly, they can move across the government authorities like GST, income tax. They have made compulsory appearing for examination of IP for many of the officers of IU, Information Utility, NESL. That is okay because it is for necessary for them, because I have delivered a lecture at that place also for at NESL for the preparation of exam. But nowadays, what I feel is IBBI should help their members by helping them, like one with they can go to income tax department, GST department, central, or they can call a meeting with them explaining the provision. Because what happens in case where I am liquidator, if I am selling a land, the person is bound to deduct 1% TDS. Now it is a priority payment which is bypassing section 50, rather regulation 50, section 53 waterfall mechanism. Now I said, sir, there are many cases which are decided by various NCLT benches wherein the income tax department was required to refund the amount of TDS which was deducted. So basically, after so many years, even the CBDT should come out with a circular, because what happens is at the ground level, the officers are not aware of all these provisions. So it is necessary that the circular should come from their head office. Like income tax, they officers will only believe in the circulars which are issued by the CBDT. हमारा circular नहीं है तो हम नहीं करेंगे. So CBDT should issue the circular that in case of cases in the liquidation, the TDS provisions should be dispensed with because it prioritizes among the others. So there are many such things which can be streamlined with various authorities, and I am expecting that IBBI should do that for their members. Yes, any other question? So I think I am thankful to the audience for attending me patiently, because the issues that are persistent in IBC are the problems which we are facing on a daily basis. And it is essential to come up with that problems, so that under such forums, if certain points are properly understood, then it is quite possible that some of you might take it at a proper level for rectification or correction. That is my only expectation. So I am thankful to all of you who are attending me patiently and listening to me carefully. Thank you for that.
Thank you, sir. Thank you. Thank you for your insights.
So Gupta madam, shall we conclude? Shall I conclude?
Sure, sir. Thank you very much, sir. The session was very wonderful, very interactive. Thank you very much, sir.
Thank you. So you can continue with the rest of your day.
Yes,
Thank you all.
there is lunch break till 2 p.m. Next session will start at 2 p.m.
Okay, thank you.
Thank you.